Welcome back. We are looking at video right now in the Stephen Foster case out of Georgia. Right now in the video, that is footage outside the hospital where Stephen Foster was taken for his blood draw. The audio you're hearing, though, is the officer inside the hospital talking with the defendant who is requesting a second blood draw. In Georgia, you have the option to request a second blood draw. And Stephen Foster in this case says that he was arrested because of an overzealous police act and that they arrested him because they knew and figured out who he was, and it was more of a media frenzy than a legitimate arrest. We did see video earlier of the field sobriety exercises on the side of the road, the walk in the straight line, looking into the eyes, the typical DUI exercises. With me is Francey Hakes. Francey, before we go to break, I wanted to give you the opportunity to comment on this case because you're with us now, so and you're with us for the next hour. So what do you think so far?
Hi, Carissa. I was also an assistant DA in Georgia, so I'm familiar with the laws there. And under Georgia law, .06 is considered drunk. .10 is presumption.
Almost twice the legal limit then. So we were both prosecutors, right? You were in Georgia, though, in this jurisdiction. So when we get back from break, I want you to let us know, because we're going to have to go to a break, whether or not he was actually entitled to a second blood draw, and what are the likelihood of this .10 having some technical mishaps. We're going to take a quick break, but stick with us, and we will be right back here on Law&Crime. Welcome back. I'm Carissa Kranz. Before the break, Francey Hakes and I were discussing the Stephen Foster trial out of Georgia. This is the Democratic candidate for Congress who was arrested for DUI. He is claiming he is not guilty of DUI, that instead he was taken into custody by overzealous police officers who found out who he was. He asked for a second blood draw, which he claims he's entitled to under Georgia law. Francey, who was a prosecutor in Georgia, has insight on that. So before the break, I asked Francey about the legal limit in Georgia, which I learned was .06, right, Francey? And
that's right,
where I'm from, it's .08. So his breathalyzer results was .103. That's almost twice the legal limit. So, Francey, what is the likelihood of that breathalyzer being wrong?
You know, it's really interesting, Carissa, because in Georgia, anyway, they say in the DA's offices that DUI is more complicated to prosecute than a murder case. And part of the reason is because of the tools like the breathalyzer test and the field sobriety tests, all of which have to be done in a very strict way. They have that horizontal gaze nystagmus where the police officer observes what's going on with your eyes, and you've got the walking and the balancing, and then the breathalyzer itself. And that instrument has to be tested a certain amount of times. There are certifications it has to have before it can be in use, and those certifications have to be renewed. I think it's unlikely that that's going to be found to have been inaccurate.
Probably they've laid the proper foundation that their breathalyzer test has been accurately used that night, just like a radar test is usually calibrated properly to prove a speeding ticket. But in this case, what's interesting is, driving under the influence means you're driving, and there's reason to pull you over, like a driving pattern. And in this case, that's another argument that the defendant is making, that there was no driving pattern indicating driving under the influence. So that's another flaw in this DUI, right?
Well, that's what he says.
That's what he says. What does the state say?
That's right. I want to see what the police reports have said, and the camera, when they turn on their lights and sirens, the camera generally turns on automatically. So I want to know what the driving pattern was that they observed. A congressional candidate in Georgia is probably not all that well known. So when he says he's being targeted, I also find that to be a little bit unlikely.
Well, what about the fact that he says he needed to have two tonics that night because he has a rare form of malaria? That probably can be proven, that he has this malaria disease that couldn't be appeased with any drugs, and that this tonic actually just made him feel better, and he wasn't, in fact, intoxicated, but he was under more of a medicinal use.
Well, Carissa, it's so interesting because people think that DUI means driving drunk. And as you noted, that's not what it means. It means driving under the influence. And that's just a certain amount of alcohol in your blood system. It's not an excuse that you were in pain and you took it. It's not an excuse if you took drugs because you were in pain. He shouldn't have been driving a car if he was under the influence of alcohol.
Right. So isn't that what a second blood draw, just playing devil's advocate here? He submitted to one blood draw and demanded a second vial be drawn. And according to Stephen's story, the defendant's story, that's when they figured out who he was and became argumentative and overzealous and took him into custody. And he never got his second independent blood draw, which he would have been entitled to under Georgia law. And had he gotten this independent blood draw, not the state blood draw, maybe it would have shown results that were in his favor, which is his argument for the defense. What do you say to that?
Well, you've got field sobriety tests he apparently failed. You've got a breathalyzer.
But I mean, in all reality, doesn't everyone fail a field sobriety test? I mean, when I was a prosecutor, the moment you were pulled over, you were losing. You were being arrested whether or not you did a good job.
Well, the field sobriety test, you're right, Chris. I mean, if you actually watch what they are, standing on one leg and touching your nose, there are many people who can't do that.
No, they can't. I'm a former ballet dancer. People cannot stand on one leg and touch their nose.
No, it's true.
If they're tired, they're going to fall over.
No, but the horizontal gaze nystagmus is a little bit different because your eyeballs react a certain way when they're under the influence of drugs or alcohol. And then there was the breathalyzer that backs up those tests.
Right. So the horizontal nystagmus test, which shows the eyes which react a certain way, there's an issue with that because the cameras don't exactly capture that. So then you have the officer's word against the defendant's word. And then on video, you have the other field sobriety exercises, which show that maybe he isn't under the influence. Maybe he really can stand on one leg just as good as the guy next door who woke up and had coffee and that's it for the day.
Well, maybe, but I think it's a combination of factors. Now, he will argue that the police had no probable cause to pull him over. That seems to me to be his best argument here. What happened after that with the breathalyzer and the blood tests that are going to show he was under the influence are bad for him. So his shot is what happened in the very beginning. That's his best chance.
All right, so we're going to continue to follow this live. As you can see on the screen right now, that's the shot outside of the hospital where he's arguing with the officer to get a second blood draw. Let's go back into the courtroom now and listen to that audio, and then we'll be back here with more in-studio analysis. Welcome back to Law and Crime. I'm Carissa Kranz. We're following closely the case out of Georgia, the Stephen Foster trial. This is the case where Democratic candidate for Congress was arrested for a DUI, and he is claiming he was not under the influence. Yes, he had 2 drinks that night, but it was because he had a rare form of malaria and needed to drink the tonic. The police are saying that he was under the influence and had a blood alcohol level of 0.103. While the defendant is saying that can't be right, he requested a second blood draw as he was entitled to under Georgia law and was not given because of an overzealous arrest when the police found out who he was. Who was he? A Democratic candidate for Congress. With me, Francey Hakes. I'm going to bring you on because the courtroom is going into a break. And let's discuss this further. I know when on the break you said that the legal limit in Georgia was 0.08, not 0.06, which I know you wanted to correct. But even so, with a 0.08 legal limit, let's not forget he blew 0.103. Guilty.
That's right, Carissa. I mean, that's well over the legal limit. That's another drink, if my math is correct. It's all about how many drinks you've had in a certain period of time. And 0.10 is a significant number of drinks in generally a short span of time.
Right. Okay. So I just got word that the courtroom went to a break. So before we continue evaluating this case, we have a special report from Anthony Velez where our other stories of top crimes are trending around the country. Let's take a look.
Here are today's top crime stories trending on lawandcrime.com and across the country. A convicted child rapist escaped from a prison in Kansas 3 days after entering the facility. 36-year-old Robert Terrell escaped Winfield Correctional Facility after he jumped a fence. Terrell was convicted of raping a child in 2002 and was recently arrested for a parole violation before being placed in the Winfield Correctional Facility. Authorities have warned the public not to approach Terrell and to call investigators. An armed bystander in Titusville, Florida, stopped a shooter at Isaac Campbell Park, potentially saving many lives. The shooter, who has yet to be identified, reportedly opened fire on a back-to-school event after a fistfight. That's when the bystander made his move, shooting the suspect and neutralizing the threat. The suspect remains hospitalized with life-threatening injuries. A woman who lives in the neighborhood where missing University of Iowa student Molly Tibbetts disappeared told the FBI she saw a suspicious black SUV creeping around the area the night of Tibbetts' disappearance. The 20-year-old student from Brooklyn, Iowa, went missing on July 18th and was last seen going for a jog before her disappearance. Investigators do not consider Tibbetts' boyfriend, Dalton Blake, a suspect and questioned the owner of a hog farm twice, but have yielded no results. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Thank you, Anthony. That's a great recap of our trending top crime stories around the country. I want to discuss for a minute the Molly Tibbetts case, where the girl went missing and is still an ongoing investigation. With me, Francey Hakes, I want to ask you, they found a body, but the body they don't think was her body. Do you think that they have more information, but they're not releasing it right now because it's an ongoing investigation, or do you think that we really don't have the information that we need in order to bring the proper suspect to the table?
Well, Chris, I think that's the really frustrating thing about missing persons cases. We discussed it this weekend on XGTV with a panel of experts talking about this case and specifically about the fact that the public is not being given a lot of information. Well, that's pretty standard operating procedure for investigations. You don't want to give any suspects any more information that might allow them to continue to elude police. So I'm certainly hoping that police and the FBI have more information than they're giving us. But this discovery of the body, even if it's not Molly, does not bode well, I'm afraid.
No, it doesn't bode well, and I hope also that they have more information that they just don't want to release because they want to find the proper suspect and don't want to tip the suspect off. It's a catch-22. Do the police get the tips, or does the suspect get tipped off, and then our whole investigation is evaded? So very important to keep all information close to the vest in ongoing investigations when we really don't have all the facts. We're going to switch gears like we always do on Law and Crime. We're covering tons of trials at once. You can always go to lawandcrime.com to see everything that we're covering. Right now, we just finished the Anthony Kirkland death penalty resentencing hearing. This is the case out of Ohio. This is the case where in 2010, he was sentenced to death for 5 murders. He's a serial killer. He was already serving life in prison for 2 of the murders and already served a sentence for an additional murder. Then he was on trial for 2 more murders. And the prosecution said in closing arguments, if you do not sentence him to death, then he basically got 2 freebies. The appellate court said that was prosecutorial misconduct and misled the jury by forcing their hand in giving and holding him accountable for the final 2 murders, saying that life in prison was already sentenced and therefore that wasn't appropriate. So we've been following that closely for over a week, and now the closing arguments just finished and we are on verdict watch. So we're going to continue following that verdict watch and analyzing what has been going on in this death penalty resentencing hearing, which is like a mini trial. We're going to start by going to the transcript of testimony from Barbara McAvoy. That is the sister of Mary Jo Newton, one of the victims, and this is direct examination. Let's take a look.
Yes.
That's testimony of Barbara McAvoy. It's a transcript, and she is the sister of Mary Jo Newton. This is significant because while Mary Jo Newton was not one of the victims for this trial, she is one of the 5 victims where he was already serving a life sentence in prison for. The final 2 victims are what the death penalty resentencing is for, because we're trying to, or the prosecution is trying to hold him accountable for the final 2 murders. With me, Francey Hakes. Francey, would you say that this is relevant because the prosecution needs to come up with as many aggravating factors as possible in order to get the death penalty sentence? Because remember, this is a victim from a trial that already was sentenced. This is done. You know, double jeopardy would say she can't be tried again. This isn't relevant, but it's relevant for aggravating factors, right?
That's right, Carissa. I mean, in the death penalty phase of a case, in the sentencing phase of the death penalty case, it's all about aggravation and mitigation, where in aggravation, the prosecution basically, I mean, it's just, this is putting it in regular language, the prosecution basically tries to paint the defendant as an evil, irredeemable human being who does not deserve to breathe the same air as the rest of us anymore. And this is just part of that tact.
Right, and you bring up an interesting point, which we heard about earlier today, but we do have to go to a quick break. So after this break, when we come back, we'll continue to dissect this case further and watch it closely in the courtroom. Stick with us. That's what you heard him say. The way things were, death wouldn't be such a bad thing. That's what the defendant said, that one of his victims said in the police interview before he killed her. Francey Hakes, you and I were discussing that comment during the transcript, and you said, wow, missed opportunity. And I said, yeah, this is the defendant's way of mitigating what he did by saying, oh, he did her a favor. She wanted to die, as if it's assisted suicide. Death wouldn't be a bad thing. Is this mitigating, or was this a missed police opportunity?
Well, I don't think it's mitigating. I think it's actually aggravating, Carissa, although it's also a missed opportunity by the police. And it's a mistake prosecutors and lawyers make all the time in the courtroom, and that is they're not actually listening to the answers. They're so tied to the questions that they want to ask that they forget to listen and follow up. And I think that the police should have followed up on that question with, well, how did she seem? What did you take that to mean when she said that? Why do you think she said it? Lots of opportunities to get right into his head. But I think the most important thing that this shows is that he's just evil. Bottom line.
Right. It shows that what we're looking at here is a man that killed 5 people. And there's no doubt that he killed 5 people. There may even be additional victims that we don't know about. But what does matter is the intent and the aggravating factors that went into each of these murders. So this is his way of saying she was asking for it. She must have been so depressed in life that I did her a favor by taking her life. Right?
Mercy killing.
Mercy killing, right. So we're going to have to take a quick break. After the break, we're going to switch gears to one of the other trials we're closely following. So stick with us, and we will give you an update in just a few moments. Welcome back to Law and Crime. I'm Carissa Kranz. We are switching gears back to the case in Georgia. This is Stephen Foster. And this is the case where Stephen Foster was a Democratic candidate for Congress who is accused and standing trial for DUI, driving under the influence. But he says he hasn't been drunk since 1981 and that these neo-Nazis beat him in prison. He says he only drank 2 gin and tonics that night, and the reason was because he had a rare form of malaria that could only have symptoms appeased by this elixir drink. However, he did field sobriety tests at roadside. He was arrested, according to him, when they found out who he was and his overzealous police activity. He was then taken to the hospital where he was given a blood draw after he as well blew .103. The legal limit in Georgia is .08, so he blew over the legal limit. Then he had a blood draw, and then he requested an independent blood draw, which under Georgia law, he is allowed to request and get, but he never got the independent blood draw before he was arrested. So we are dealing with a trial right now where he says the police overreacted and he wasn't drunk, but the police say, nope, we have the evidence, we have the breathalyzer test, we have our blood draw, and the facts are the facts. With me, Francey Hakes and Bob Bianchi. Great to have 2 guests with us to discuss this trial. Bob, I want to give you the opportunity to talk first because during the break, you told me that this guy was crazy. Why?
You know, when you do this long enough, you have to stop saying, I've seen it all, because then a guy like this comes along. First off, he says he's in the bar, hanging out, he's drinking the tonic because it helps him with his malaria condition that he contracted when he was a doctor. Well, you don't have to put the gin in the tonic in order to get the malaria. I didn't know that gin was somehow some sort of medical ability to be able to help him with that. That's number one. Then he says he only had 2. Then he says he was with his wife. It turns out he wasn't with his wife. Now let's get to the legal pieces. He comes out of the bar. He's driving without his headlights, so the cops have probable cause to stop him. They have very well documented that he couldn't pass field sobriety tests, which gives them the probable cause to bring him in. He goes with the breathalyzer. They believe he's under the influence. He blows over the .08 legal limit. But that's just basic stuff for this congressional candidate, this person who wants to protect us, wants to go to Congress and pass laws and have laws enforced that make us a better community. Then we find out that he was in the Army, he was serving in a medical clinic, excuse me for looking down, and that he was actually suspended indefinitely in 2002 for failing to complete, you're not going to believe this, a mental and physical examination. What a shocker. So he basically doesn't do that, so he gets suspended permanently. And his argument as to why he got suspended, because they believed he was mentally unfit, was that he referred to the CIA as opposed to the CID, which is an investigative division, when they asked him about any lawsuits. And that because the doctor that was evaluating him wrote the CIA down, they thought he must be out of his mind. Rather than fix a ministerial mistake, he claims based on that fact alone, that's why they indefinitely suspended him. I'm calling bull dinky on that particular thing. And I'll tell you why I'll add to that. Because when the cops are asking him about where he wants his blood submitted or where he wants it to go, you're never going to believe all these years later where he says he wants it to go. He wants it to go to the CIA. Again, the same thing about the CIA. So I guess the doctor that evaluated that said he was inappropriate or he wasn't fit to be a doctor years and years before brings up the CIA. Ironically, with the police, he mentions the CIA. And then he says, well, I just said that because I knew I was going to be arrested anyway. So listen, this guy, you got to love this case. You got to love Law and Crime. How those guys, how those producers and people are finding these cases, I don't know. But this is going to be theater because he is going to take it to the hoop. He has committed to that. I say guilty of that and guilty of, oh my God, who are we almost sending to Congress?
Okay, so you say he's guilty of DUI no matter how you cut it. But I can tell you, and as a former prosecutor, I would prosecute the case and make all your arguments. Those are great arguments to convict him of a DUI. But number one, let's talk about the fact that it was just headlights. That's not a driving pattern with which to pull him over and to say, oh my gosh, he has a driving pattern of weaving in and out of lanes and therefore was a hazard and therefore he's driving under the influence and was intoxicated. According to him, it doesn't matter who was in his company, whether it's his wife or a friend. He probably lied because he's embarrassed that he should have been with his wife and was with another female friend. But that doesn't mean he was lying over whether or not he was actually intoxicated. And don't you think that we can prove, or the defense can prove, whether or not malaria or that rare form existed in his bloodstream? I'm just playing devil's advocate here because the defense must have a defense.
Well, Carissa, that was a great defense pitch for 3 points that you brought out. The fact that he's even telling the cops that, hey, I'm not really a drinker. I can't even believe the detail he's talking about it. I got hammered on Long Island iced teas at a bachelor party in the 80s. And since that time, blah, blah, blah. Here's the thing to your points. Number one, it doesn't have to be erratic driving to be pulled over by the police. It could be for a motor vehicle infraction. And the motor vehicle infraction here is that he failed to put his lights on, which is something that most people typically would do. When they get him out of the car, they smell the odor of alcohol. He's answering in a bizarre way. They get him out. They do standard field sobriety tests. He cannot successfully perform one of those standard field sobriety tests. And under the law, that's probable cause to bring him in to have a test done. And he takes the test, and he fails the test. So the fact that he's got malaria, I feel bad for the guy if in fact that is correct. But then you just drink the tonic or you do whatever you do. You don't need to include the gin on it. The bottom line here is that the defense is going to have a very, very hard time unless they get the evidence suppressed that this guy took a breathalyzer and 0.08 or higher, his 0.08 is higher, his 0.08 is higher. End of story. Plus, let me get to the last point you brought out. The fact that he lied about the girl, paramour, whatever she is, shows the guy is a liar. And then when he's bringing out these crazy statements about sending his blood results to the CIA, I think that's going to be used as further proof that the guy was in an altered state, an altered condition. I can't see how the guy can escape this based upon my pretty extensive knowledge of how DUI trials work, unless something gets suppressed on a technicality and the guy lucks out.
Well, Counselor, I would say that you would have given an excellent opening statement and a closing statement for the prosecution in this case about what you're going to see and what you saw, because you certainly left little room for the defense to have any argument whatsoever. But there's a reason he's standing trial and not taking a plea right now, and I'm curious as to what it is. So let's take a look at defense opening statement to see what they plan to show us that could possibly redeem this guy. Let's take a look. That was defense opening statement in the Stephen Foster case out of Georgia. This is the DUI case where a Democratic candidate is saying he's not guilty of driving under the influence and that the state messed up by not giving him the blood draw that he wanted and by not testing him properly within the time frames. Bob Bianchi is joining us to discuss this. And before we went into the defense opening statement, Bob, you gave a very compelling prosecution argument. But now that you heard the defense in opening lay out the problems, the inconsistencies with the drinking, and why the blood draw had to happen then and not be delayed, because if it was delayed, it would elevate the findings, how do you respond?
Remember the good old days of being a prosecutor, because the bottom line here is he failed the field sobriety test and he blew over on the breathalyzer or the alco test. I don't know which machine they're using there, and that is pretty solid evidence. However, if in fact what he is saying is true with respect to the blood, and Georgia allows you to be able to have independent testing, which I think is a great law to have, and it was not done properly, you could make an argument down the road that, you know what, folks, listen, Carissa, let me just put a sidebar real quick before I say it. There's also an allegation the defense is making that when he wanted to have these tests done at the hospital, that there was radio transmissions going back and forth with the police, where the police indicated, oh, you got him, the guy who's running for Congress, just bring him in. In other words, if they could establish that, and that should be on audio recordings, if in fact that is true, if it's not true, it hurts the credibility of the defendant who has been suggesting that. But if it is true, then they could say they deprived them of a due process right, deprived them of this law is there for a reason, so that you don't have to just rely on the police, and therefore you should have reasonable doubt because they treated him differently and didn't follow the rules and regulations. And we all know, last point, Carissa, that when you're dealing with the breathalyzer or with the alco test, it has to be done exactly and precisely correct. And if they have an expert to indicate that it wasn't, then that could potentially substantially skew the results. But boy, that's a lot to believe that these cops were pigeonholing him. He's driving without his lights. He's giving these crazy answers about the CIA. He can't do field sobriety, which is probably on body cam. He blows the .10. You'd have to argue that they falsified that or did something wrong with that. Then this argument that the defense attorney is raising about how the blood was preserved and sent over may resonate. I say he's got a tough job ahead of him.
Well, he does have a tough job ahead of him based on everything you're saying, but it'll be interesting to see what the defense actually puts on. And the defense always has a case to put on when they come to trial with their own bags of goods with which they will perform their case. We're going to take a quick break, so stick with us and we'll come back. Welcome back to Law and Crime. I'm Carissa Kranz. We are following closely right now the Stephen Foster trial out of Georgia. This is the DUI case where a Democratic candidate for Congress was arrested for driving under the influence of 2 gin and tonics because he claims he had a rare form of malaria. Before the break, we had Bob Bianchi explaining the prosecution's case, saying this guy is crazy, he's definitely guilty of DUI, that there's no reasonable doubt, and then we played the defense opening statement, and then Bob came back on and held his position that no way the defense has a case. So, Bob, I want to bring you back on and to discuss this with you, because when I'm listening to this, and I agree, a former prosecutor here, I agree, this is a case that I would probably want to try, and I do think I could have a jury find him guilty. However, I disagree that there wouldn't be any reasonable doubt. When the defense puts on their case, why couldn't the blood draw show he had that malaria? And if he did have that malaria, then I would say that that adds some credibility to his argument that There was no medication for it, and this was just more of a medical elixir. And just because he blew over the legal limit, that's a presumption of driving under the influence while intoxicated. But that doesn't mean he was actually under the influence and intoxicated. We have issues with the possible breathalyzer, according to the defense. We have a blood draw that wasn't done as an independent examination like he requested. The time frame of the blood draw is important. I'm just playing devil's advocate here that the defense has a case, and if the defense didn't have a case, then the defense wouldn't be standing trial right now. They would take a plea deal. So why not take a plea, Bob?
Well, but there's a lot of assumptions, Carissa, in what you're saying. And first of all, I'm not saying the defense doesn't have a case. The defense can always have the case if they can question the credibility of the officers, and that would really hinge on this supposed statement that was made that they were actually trying to kind of shaft the guy because of who he was. And if he can develop that evidence in a competent way, you may be on your way to try to attack all the other observations that were being made in all this. But that is a very, very tall order. Now, I don't know the state's laws exactly, but I can only tell you from what I know here in Jersey and New York, and I believe virtually everywhere else, maybe it's different. If the machine is operating properly and you're over a .08, that's it. It's a per se violation of the law in most jurisdictions. And let's also not forget this point, Carissa. Even if you can throw the breathalyzer results out or create enough reasonable doubt where they thought it wasn't done properly or what have you, the officers can still convict on observations alone. My last point to response to your question, and you're bringing up very great, valid defense arguments. They're the arguments I would bring up too, but the question really here is the sufficiency of those arguments against the other evidence and using our experience to determine whether or not you can prove a case beyond a reasonable doubt. The fact that he may have malaria, I'm going to give it that he does have it, does not mean that you can go into the Applebee's or wherever he was and decide that you're going to mix gin, an alcoholic drink, into that tonic that supposedly helps his malaria condition. And the bottom line is, based on the observations of the police officer alone, the field sobriety test, the fact he didn't have his lights on, the cockamamie statements he's given about the CIA, his pushback, his attitude, the way he was acting, I say you don't even need the breathalyzer. You had a good breathalyzer result on top of that, and every one of these other defenses, while valuable, while I would argue them as you're indicating, go away because it's a per se violation in my mind if the breathalyzer results are admissible.
Correct. And the jury is going to be the final say on that. And the jury also gets to look at the field sobriety exercises on video, and they get to decide whether or not the defendant appeared intoxicated. And what's important that the jury understands in those circumstances is that intoxicated does not mean wasted. And that's what Bob is getting at when he says that there's the per se presumption of being under the influence, under the legal influence at .103, because that doesn't mean you have to be wasted. It just means you have to be intoxicated. We're now going to go to testimony from Justin Smith with the Dalton Police Department, and we're going to then come back to evaluate this case with Francey Hakes and Bob Bianchi. Stay tuned. That's cross-examination of Justin Smith with the Dalton Police Department. He is the arresting officer, and we are hearing the defense say and poke holes in the prosecution's case. Some key holes we just heard is there's no driving pattern with which to arrest him. He even used his turning signal. The only driving offense is that he was driving without headlights turned on. That is not a driving pattern. The second thing that we heard him highlight is that there was no slurring of the speech, and if there was slurring of the speech, that would indicate intoxication, and then therefore he could have been found more guilty of driving under the influence. Just because he blew a .103 doesn't mean that he was intoxicated for his body under the law. So this is going to come down to circumstances, and even though he smells like alcohol, one drink can do that. That doesn't mean that you are driving under the influence to the point where you are legally guilty of DUI. Now, I'm a former prosecutor, and we have two other former prosecutors here with us today. So I am putting on the defense hat, which is hard for me to do. But I think it's important to really look at a case because a jury must weigh all factors in a case. So, Francey, I want to give you the opportunity to respond to defense's cross-examination, which I do think is powerful in lending circumstantial evidence and poking holes to the prosecution's case, that just because he had this .103 doesn't mean he was guilty under the law of DUI. There's an argument to be made.
Yeah, so Carissa, this is classic defense tactic misdirection, right? Don't look over here at the law the defendant broke, that is failure to use his headlights at 2 o'clock in the morning, which even in rural Georgia, Dalton is a bit rural, is against the law. Instead, look at all the things he didn't do. This is classic defense tactic, but it doesn't negate the fact that the defendant was driving without his headlights, which is a violation of law, and which allowed them to pull him over. They don't need 14 infractions to pull him over. They only need one.
So you're basically saying that just because they didn't document the slurred speech doesn't mean that the speech wasn't slurred. It just means that that was one thing that may have been an oversight, and that because he didn't turn his headlights on, even though that's not a driving pattern, that indicates that all his faculties were not together enough that night, that he didn't remember to turn on the headlights, an otherwise simple task, and had he not been drinking, that's something he would have remembered. That's what you're saying as a prosecutor, right?
Well, no, the slurred speech, I mean, I think that if his speech had been slurred, it should have been documented by the police officers. And one of the things I think that the officer on the stand conceded was that he didn't notice any slurred speech and that the defendant was talking a lot. Although I would argue that talking a lot can be another consequence of being intoxicated. And one other thing I wanted to point out, Carissa, and by the way, you're doing a great job presenting the defense side of things and putting on that defense hat. But the fact that the defendant was talking a lot and had an infraction of law is all the police needed to apply all the field sobriety tests and give him a breathalyzer or whatever the alcohol test was. It does not negate their probable cause at all, even though the defense is trying mightily to make it seem as though it does.
All good points, Francey. And if I were the attorney in that case and I could have given him advice ahead of time, I would have told him don't give in to the field sobriety exercises, don't blow, and don't give the state any evidence, because then they would have no case. Now the jury has to evaluate it. We need to take a quick break. Stick with us. Welcome back to Law and Crime. I'm Carissa Kranz. We are now switching gears to the Anthony Kirkland, Ohio death penalty resentencing hearing. We are on verdict watch in that case, and we are watching the courtroom really closely. For those of you just joining us, this is the case where the serial killer Anthony Kirkland killed 5 women. Will the jury go for the death penalty again? That is what is to be seen. This is a rehearing for the convicted Ohio murderer. The original jury recommended death sentences, but due to prosecutorial misconduct in closing arguments, specifically that the prosecutor was said that these other 2 murders that are now on trial would be considered freebies because he was already standing trial life sentences for the other murders. Remember, this is a rap sheet of 5 murders. That was found to be improper by the appellate court, and now here we are 8 years later having a death penalty resentencing hearing. The jury is out deliberating. I want to bring on Francey Hakes and Bob Bianchi to comment on this while the jury is out. What do you guys think? We're going to get a verdict, a fast one? Francey, go ahead. You first.
Yeah, you know, Carissa, it's always so hard to predict these sort of things. I always feel like, especially after the prosecutor's closing argument, which I thought was very powerful, and all the aggravating evidence here, I feel like it should be a relatively easy and quick decision. But the thing is, when jurors go back into that jury room to deliberate, they really take their job seriously. And remember, this jury did not actually hear the guilt-innocence phase. So they're looking at this case all brand new to them. So I don't think it'll be a fast verdict. I think that even the jury in the jury room would think that was unseemly. They'll be going through the evidence. They'll be discussing it. They'll probably take multiple votes. It's a very serious and solemn duty to apply the death penalty, and it's a very difficult thing. So I don't think it'll be fast, no.
Well, and that's a good point, Francey. This case was tried back in 2010, and then there was a death penalty sentencing hearing, which is a mini trial with the same jury around that time frame. But since it was appealed, here we are 8 years later, it's a new jury. Though the same prosecutor is seeking the death penalty, it is a new jury, and this jury did not hear the actual trial and all of those aggravating circumstances. So this jury now has to rehear testimony about 5 other murders, or 5 murders total, his whole rap sheet, to decide whether or not he's worthy of the death penalty. And one thing that I found interesting was his own statement that he said to the court. He said, "I cannot offer any justifiable explanations for my senseless acts. I neither expect mercy nor forgiveness. I am not looking for absolution. Eventually, I will answer for a higher authority. But I do not blame you if you kill me. I do not deserve to be here. But please spare my life. Kind of powerful testimony to hear from the defendant himself. He is admitting that he is wrong, but he is also pleading with the jury and the court to spare his life and let him answer to a higher authority. Let him answer to God, is what he is implying, rather than to a panel of jurors who could take his life. We are going to now go to a clip. It's a deposition of Gary Rollison, and he is the father of Kimya Rollison. Let's take a look and see why this is an important clip. That's Sergeant Jennifer Mitch with the Cincinnati Police Department. This is the case in Ohio where Anthony Kirkland is standing trial for a death penalty resentencing hearing because in 2010 he was sentenced to death for the last 2 murders he committed of the 5 that we know about. With me, Francey Hakes and Bob Bianchi. I want to discuss this case. We're hearing about aggravating circumstances with prior victims. Right now, this is a victim that wasn't even related to the final trial. As Francey brought up earlier, this is a jury that didn't sit through the trial of the last 2 victims where death penalty was on the table. So in a way, this jury is hearing a trial of 5 victims all at once. Francey, do you think that that is aggravating, mitigating, or too prejudicial, or more probative and necessary in order to get a proper, fair sentencing hearing?
That's a great question, Carissa. I think it's perfectly probative and appropriate because he did it. He murdered 3 women and 2 children. And I think the important testimony from the detective, Jennifer Mitch, the sergeant, I think she is, the Cincinnati Police Department that we just heard, was in particular very aggravating. And that is, in spite of what we heard from the defendant about, oh, one of the victims really wanted to die, she thought it would be good. So he's trying to argue it was a bit of a mercy killing. This particular victim, Kimya, was left like trash in an area where trash is dumped. Her body was burned. They couldn't even identify her from her remains. So this is definitely aggravating for a jury to hear the way that the offender, this murderer, this serial killer, treated his victims is aggravating in the extreme.
Right. But what's interesting to that point is that these are awful aggravating factors and circumstances. But this defendant already stood trial for these 2 murders that you're discussing. And for those trials, his sentence was life in prison, not the death penalty. It wasn't until 2 more murders and another trial that the prosecution said, you must give the death penalty or these final 2 murders are like freebies. So while I agree with what you're saying, that it does sound aggravating and worthy of the death penalty, that wasn't what happened that wasn't the sentence. It's more of a cumulative now response for the prosecution to lay out, to let the jury decide whether or not now all of that should be considered. So,
but Carissa, I'm sorry to interrupt you, but the one thing that's really important to remember is that they're seeking the death penalty on the murder of 2 little girls. They're 13 and 14.
So that's what's aggravating.
Yes, that's what distinguishes it from the original 3 cases of adult women. Although I think that they had a case for the death penalty then, they definitely have a more strong case now when you're talking about his rape and murder of little girls.
Okay, we need to go to a quick break. I didn't want to cut you off there, but stick with us and we will come back to further discuss this trial and more about it. Stay with us. Welcome back. I'm Carissa Kranz. Before the break, we were discussing the Anthony Kirkland death penalty sentence rehearing trial out of Ohio. And with me, Francey Hakes and Bob Bianchi, we were in a heated discussion on whether or not the death penalty is appropriate in this case. We were listening to testimony that went over the prior murders, the murders that he was already found guilty of, and serving a life sentence for. Now he was found guilty of an additional 2 murders, and the question is death an appropriate sentence? During this resentencing hearing, we are hearing testimony from all the victims. There's a rap sheet of 5, or the victims' families and the victims' deposition testimony, to decide and determine whether or not the factors are aggravating enough to sentence him to death, because initially the prosecution said if you don't sentence him to death in 2010, then the last 2 murders are like freebies. Now we have a different jury, but the same prosecutor seeking death. This jury doesn't get to hear the whole trial over again of the final two murders, but they get to hear in the death penalty resentencing trial a mini trial which covers all 5 of the murders. And the jury is to decide whether or not it is aggravating enough to sentence him to death. Before the break, Francey Hakes got an opportunity to get in her 2 cents. I want to give Bob Bianchi an opportunity to give us his thoughts. So, Bob, what do you say?
You know, Carissa, as a death penalty litigating prosecutor, I came to not agree with the death penalty because of the disparate way in which these things are treated within the states and among the states. In New Jersey at the time, and I'm pretty sure I checked the state laws on this earlier when I was hosting, the aggravating factors typically deal with the crimes with which the individual is currently before the jury. As you aptly put out before, stated before, these other women, he's already paying the sentence. So it's what we call in some areas of the law, double counting or a cumulative effect. The aggravating factors are very specific about what prosecutors can argue. Now, apparently, in this state, this must be allowed. I have to just accept the judge would not allow this victim impact testimony from all of these individuals unless they believe that it was relevant. But you have to wonder, when you do so much of that, where does it get to a point where the emotional reaction of the jury is so overwhelmed that it can't literally look just at the 2 little girls here? I think there's enough for these young girls to impose a death penalty. I believe he will get the death penalty. But once again, I'm going to go back to my mind that when this circles its way through the courts and the state courts and the federal courts and potentially the Supreme Court, if some court's not going to say that the cumulative effect of all of these victims being brought into this trial incapacitated the jury from following its oath as far as weighing, aggravating, and mitigating.
You bring up an important point about the cumulative effect of all these 5 murders, which is what the jury is hearing now, and they're probably going to sentence him to death. But we are on verdict watch right now, and we will keep a close watch on the courtroom to see if that's what this jury decides. But the other question that can percolate in the brain is we're hearing about the victims that did already die, who he served life in prison for, or was under that sentence for those trials, and it does make you wonder why he didn't get death in those cases. But right now we're talking about the 2 little girls that died, and that is an aggravating circumstance, and there is the cumulative effect. We do need to take a quick break, but when we return, we'll have more in studio now. Welcome back. I'm Carissa Kranz. With me, Francey Hakes. I want to give you the opportunity to respond to the death penalty topic that we were discussing in the Kirkland trial before the break, and then I know you have to go for the day, so thank you so much for joining us.
Thanks for having me, Carissa. I just wanted to say one thing about what Bob Bianchi said. The defendant committed these crimes. He killed 5 people, including 2 little girls. So it's his decisions that put him in the dock. And I think a jury has the right to know who he is and what he's done. And I don't think the Supreme Court is ever going to disagree with that.
All right. Well, thank you, Francey. We'll see what they do. We're on verdict watch there right now. And thank you for joining us. We'll see you back here soon.